Hello and welcome. My name is Jeremy Glover, and it's my pleasure to introduce our latest Fenwick Elliott webinar. This month sees the return of what has quickly become one of our more regular and most important themes, building safety. This is such a fast-moving area in terms of new legislation, new obligations, and concurrent commercial and legal considerations that we thought it was time for another update. Fortunately, we have two experts from Fenwick Elliott, Senior Associate Ben Smith, who over the past 2 years has developed a particular interest in and has subsequently become increasingly knowledgeable about these issues. And he's joined by Samantha Jones, counsel from 39 Essex, who was instructed as lead junior counsel to the Grenfell Tower inquiry and was recently described by Legal 500 as being an exceptionally dedicated and thorough barrister, someone you can count on to leave no stone unturned and to get to the bottom of any problem you may have. Bright, talented, extremely committed. She's a natural leader and a real asset to any legal team. So you can see we're in the best of hands. So just a reminder that you're all on mute. Please do send in any questions, and you'll be able to find the slides on our website later in the week. A link we put in the chat during the webinar. But Ben, over to you.
Thank you, Jeremy, and welcome everybody to this webinar on the Building Safety Act. As Jeremy says, I am a senior associate at Fenwick Elliott. I specialise in construction disputes, and over the last 18 to 24 months, a significant part of my practice has been taken up dealing with the Building Safety Act. And I just outline what we're going to cover today. Which should be appearing on your screens now. So in terms of the agenda, I'm going to quickly cover where we are now, as we're now just under 18 months on from royal assent in relation to the Building Safety Act and the various secondary legislation, statutory instruments that we've had over the past few months. We're going to touch on the new regulator, what it is going to regulate and its powers. We're also going to talk about the new duty holder and gateway regime and briefly touch on the golden thread. And then lastly, we will talk about how parties might think about managing risks, so commercial and legal risks as a result of the Building Safety Act and the new legislation, and also how that may have a wider impact on their businesses in terms of funding and financing of those businesses and new jobs. And lastly, we'll do a very brief case law update just to cover off the new cases, both in the TCC, Court of Appeal in this case actually, and the first tier property tribunal that have happened in the last 6 months. So the first thing I just want to talk about is the Building Safety Act. As I'm sure you're all familiar with by now, the purpose of the Building Safety Act is to ensure the safety of people in and about buildings and improve the standards of those buildings. And the Building Safety Act does that in 2 ways, really. Number one is to ensure that future higher risk buildings, as they've been defined, are built safely in accordance with the relevant standards. And the second way is to give avenues to parties, particularly parties who otherwise weren't previously empowered, so freeholders and leaseholders, to make claims and remediate their buildings to make them safe, particularly where they've got fire safety and or cladding defects. This is very much aimed at one of the kind of key principles that sits behind the Building Safety Act, which is the idea that the polluter pays, i.e. the party at fault should be the party that pays for the remedial works or in some way compensates the parties affected as a result of that defect. I just also wanted to touch on here the implementation of the Act. It may feel like the Building Safety Act and Bill, as it was before then, has been with us for a very long time, but in actual fact, we're only 18 months on, in fact, just under 18 months on from royal assent. This is the government's implementation slide that I've just put up there. And I think it's safe to say that there has been a significant amount of change for the industry in the last 18 months. And that despite delays, we would say on the government side, in terms of when things were going to be released and giving the industry enough time to come up to speed with those changes, they have sought to stick steadfastly to this timetable. And just to kind of recap in this period, we've seen secondary legislation around the definition of high-risk buildings, which we'll touch on briefly today, the new gate holder and duty holder regimes, gateway and duty holder regimes, which again we'll talk about today. We've seen the responsible actors scheme come in. We've had cases decided in the TCC on the basis of various provisions of the Building Safety Act, such as Mullally and Downing and ESL, and also URS and BDW, which Sam will talk about later today. We've also had the first decisions of the first tier tribunal in relation to cost contribution orders and remediation contribution orders. And there's been secondary legislation around the registration of high-risk buildings, the replacement of the approved inspector regime. So all in all, a lot has happened in a very short space of time, which is part of the reason for this webinar, is to bring you up to speed with some of the more recent changes. So firstly, I want to talk about the Building Safety Regulator. Just bear with me a moment, slight delay on the slides. So part 2 of the Building Safety Act creates the new regulator, often referred to as the BSR. The Building Safety Regulator sits as part of the Health and Safety Executive, and it has 3 main functions. One is overseeing safety and standards of all buildings. Secondly is helping and encouraging the industry and building control professions to improve their competence. It does that partly through carrot and partly through stick approach, and also by leading implementation of the new regulatory framework for high-rise buildings. I have to say that there has been concern, I think, within the industry, and certainly concern on our side, that as to how fit or able the regulator will be to police the requirements, because they are onerous and they are detailed, and whether it will have the sufficient capacity to do so in order to comply with the various deadlines it set itself, for example, for approving Gateway 2 and Gateway 3 applications. We don't have a lot of visibility on that, it has to be said, and maybe the proof will be in the pudding, but it is something to bear in mind when you get to the point, and we'll cover this in more detail, of tendering for jobs, as to whether you need to leave more time than the minimums that are required in the gate holder regime to take into account possible regulator delay. So the new regulatory regime, as it says on the slide there, effectively creates powers to prescribe requirements on those who procure, design, plan, manage and undertake building work, and introduces new enforcement powers for building control authorities. I mean, in a nutshell, if after the 1st of October you plan to either build a new HRB, high-risk building, you're going to create a HRB through either a change of use or an alteration or extension to an existing building, or you plan to undertake work to an existing high-risk building and you don't fit or fall within the transitional provisions, then you're going to be subject to the new regulatory regime. So those transitional provisions, actually, before we get there, and this is just hopefully a helpful summary slide which shows now the buildings that are regulated by the regulator and by the Building Safety Act, both during construction and occupation. So as you'll see there, the first kind of threshold test is whether your building is 80 meters or 7 stories and above. And then it's whether it's residential with 2 dwelling units or other units of living accommodation, which includes student accommodation, so you're regulated during construction and occupation. Hospitals and care homes regulated during construction. And then you've got hotels, which fall outside of that definition for both construction and occupation. Military barracks, which until a couple of days ago, everybody thought would be outside of these regs. There's been a press release from the government a couple of days ago announcing that they're planning to amend the definition of high-risk buildings to include military barracks. I assume that that's both for construction and occupation, but that's not totally clear as yet. Secure residential institutions, i.e. prisons, are outside of the regulations, and then mixed use accommodation, which obviously is very common, again, where it contains 2 or more dwellings, or basically where you can live, that's caught during construction occupation. Pure commercial buildings or buildings with only 1 dwelling sit outside the regs. So the next point to consider is if you're going to be caught by those transitional provisions, i.e. can you take advantage of the existing regime, or will you be caught by the new regime? Because as it says at the top of the slide there, not all high-risk buildings will fall under the ambit of the new regulator. So the test for the transitional provisions is either your initial notice was deposited and accepted before the 1st of October 2023, or your full plans, your full plans, had been deposited with the local authority, again before the 1st of October 2023, and your building work is sufficiently progressed by the 6th of April 2024. So the definition of sufficiently progressed for new high-risk buildings is pouring of concrete for the permanent placement of the trench, pad or rough foundations, or permanent placement of piling. So I suppose it's at that kind of midway. It's not a significant amount of building work, but equally it's not, the threshold isn't as low as it was previously, which was effectively kind of digging 1 or 2 trenches in order to start work. And if it's work for existing buildings, sufficiently progressed is effectively when the work itself has started. So if you meet that test, or that combined threshold test, then the old regime will apply, and if not, you'll be subject to the new building safety regulator, duty holder gateway regime, etc. So now I just want to come on to cover some of the new obligations that come out of the new statutory instruments. So the first big one is duty holders. So duty holders apply to all buildings, and it's a new regime that's designed to improve accountability throughout the development of building works and effectively the entire life cycle. As you'll see on the slide there, the duty holders are defined as the client, principal designer and other designers, principal contractor and other contractors. Now that's very similar to the language used in the CDM regime, but they are, to all intents and purposes, separate regimes. When you get into the detail of them, they are quite different. Some of the key kind of obligations on the duty holders are, and as again you'll see on the slide, it says that a client must make suitable arrangements for planning, managing and monitoring a project so as to ensure compliance with the relevant requirements. Now this obligation to comply with relevant requirements, or all relevant requirements, is repeated consistently through the duty holder obligations, and what it really means is that the onus for demonstrating that you comply with building regs and whatever other relevant requirements there may be now falls on the duty holders. It falls on the client, it falls on the principal designer and the principal contractor. So i.e. it's shifted away from the approved inspector regime. So it's on those parties to demonstrate compliance, and furthermore to demonstrate that they've got competencies, so the relevant competencies to carry out the works in the first place, and demonstrate those competencies to the building safety regulator, which is partly how the duty holder regime and the gateways interact. There's also an obligation to effectively cooperate with other parties, so parties don't become siloed in their obligations, and obligations to communicate and provide information to your other duty holders to give them the information, so they have got the information they need to carry out their roles. So just moving on to the practically for contractors. So a principal contractor is effectively required on any project that has more than one contractor on it. The principal contractor is responsible for planning, managing and monitoring the works. It's got to cooperate with the client, the PD and others, and here you'll see that general obligation again. You've got to make arrangements to monitor the building work, keeping records, and to ensure that the work complies with all relevant requirements of the building regs. It's really broad brush, onerous obligations that come with the duty holder regime. You've got to ensure that all those working on the project cooperate, communicate and coordinate with the other parties, and you've got to manage the flow of information. Just to note there that it is possible for principal client, principal designer, or principal designer, principal contractors to be the same people, but what's important is that they've got to make sure that they've got the right competency requirements, so they can meet the competency requirements to act as those parties. So it'll still be possible, for example, to be D&B, or be a developer who also designs buildings, but you've just got to make sure that you've got the competency to do so. And then just to cover off duty holders, designers. So they're very, very similar, as you'll see. So again, plan, monitor and monitor, but this time in relation to the design works during the design phase. Cooperate with the other parties. Again, key obligation here is the designer's got to make arrangements to monitor the building work and to ensure that its design, if it was built as it is designed, would comply with all relevant requirements of the building regs. Again, you've got to ensure cooperation, communicate and coordinate your works with the other duty holders, and you've got to manage the flow of information. Also, kind of importantly for principal designers, they're not entitled to start work unless they're satisfied that the client is aware of its duties in order for the building works to be carried out. So again, some fairly onerous obligations there. And I think on that note, I'm going to hand over to Sam to talk to you about the new gateways.
Thanks, Ben. Just while the slide's coming up, I was interested to know, you said that there were similarities between the CDM regime and this new regime that's come in force because of the Building Safety Act and the regulations. Could you have the same person fulfilling the role of the principal contractor or principal designer under the two sets of regulations, do you think?
Yeah, I see no reason why not. I mean, I think the key, well, there's 2 points. One is that government have openly said that they adopted the same terms because they thought it'd be easier for the industry rather than bringing new terms. I'm not sure I agree with that logic. I think using the same terms can be quite confusing because the roles are quite different. One is effectively a health and safety role, and the other is a building safety role. When I think, as I alluded to, when you get into the detail of what the duty holder is doing under these new obligations, which sit within the new secondary legislation, they are quite different to the CDM regime. But that's not to say that you couldn't have the same person for both, and it may well make sense to do so, particularly depending on the skill set of that individual and the kind of makeup of the organisation.
Yeah, I agree. Great. Okay. Well, moving on to the new gateways then. So these come into force because of the Building High Risk Buildings Procedures England Regulations 2023 and the Building Regs Amendment England Regulations 2023, which came into force on the 1st of October. So hopefully you're all completely fully on top of it and fully aware, but just in case you're not, here's hopefully a helpful recap of the important aspects of gateways 1, 2 and 3. Now, the important thing to emphasise is that these are changes to the building control process, so the application process and the information required, not the building regulations themselves. And the whole purpose of this regime, as with the general sort of regime change with the Building Safety Act, is to strengthen regulatory oversight before the building work commences, throughout construction, and before the building is occupied. So it's making sure that the building safety regulator can basically have one eye on your building construction project from the get-go, and trying to fill the gap that certainly findings and evidence from the Grenfell Tower inquiry demonstrated was lacking in the current building control regime. Just as a reminder, as Ben said, the buildings subject to the new regime are not existing HRBs, high-risk buildings, unless it falls into one of the 3 categories that I've set out at the bottom 3 bullet points of this slide. So unless you're doing work to an existing building that causes it to become an HRB, you're changing use of an HRB, or it's a completely separate construction of a new HRB in the first place. So first of all, Gateway 1, I'm not going to touch on in great detail, it's just here for completeness. That was introduced now a couple of years ago, and it's just to ensure that there were new requirements introduced into the planning system to ensure that there was things like a fire statement included in the relevant planning permission applications, and greater HSE involvement before the permission was granted for developing an HRB. Gateway 2. So Gateway 2, we find in detail of it in regulations 3 to 7 of the Building High Risk Building Procedures Regulations 2023. And helpfully, you might think, is that throughout the Act, although we're calling it Gateway 2s and 3, there is no reference to that terminology in the regulations, or actually in the Building Safety Act. So that's unhelpful. But anyway, we're here to tell you where to find the information about these gateways. So what is Gateway 2? So Gateway 2 is an equivalent of the deposit of plans stage. It replaces that stage, and it requires you to put in an application to the building safety regulator for approval of work prior to construction work beginning on the high-rise building, or prior to construction of a stage of work beginning on a high-rise building. The important thing to note is that there is a hard stop in this regulation. It comes in by virtue of Regulation 3, which is that construction cannot begin until the building safety regulator is satisfied that duty holders' design meets the building regulation functional requirements, any extra requirements that they may specify, and they've been notified of a start date for commencement of the building works. So essentially, you have to kind of sit pretty until that decision has been made. What I think it does mean is that clients will need to start getting all their ducks in a row sort of well before you're ready to start practical sort of breaking of ground of the project, because as you can see, there's a 12-week time limit and deadline for the BSR to make that decision about that application. So you've potentially got 12 weeks or longer to wait for the BSR to approve that application until you can break ground. So that's quite a significant time that you need to be building into your process for preparing for the construction project to begin. Just to add further potential delays into that time frame, there is a consultation requirement in the regulations. It's Regulation 6 for new HRBs and Regulation 14 for existing HRBs. So that means the regulator is mandated to consult the enforcing authority and, where relevant, the sewerage undertaker. And they're allowed 15 days to respond to this application being made. So that deadline can also be extended if the BSR and the consultee agree. And then the BSR can come back to you and can agree to extend the deadline, that 12-week deadline. So again, there's a lot of potential for delay before you can have that decision approved and before you can start work on your project. Now my slides have jumped to the beginning, so let me just see if I can get back to, there we go, there. The consultation response to introducing these regulations, the government's consultation response said that there would be guidance provided about Gateway 2. They accepted that there was more guidance that was needed about how Gateway 2 would actually act, sort of would work in reality. But on my Google searching the other day, no guidance has yet been issued or provided from the BSR. So that's certainly one to watch out for. Gateway 3 then, which comes in by way of regulations 40 to 44 of the 2023 regulations. So when does this apply? This applies for when building work on your HRB has been completed. It's equivalent to the completion or final certification phase of your project. Now, again, helpfully, you may think that the word completed is not defined in the regulations or in the Act. But as you'll see in a minute, when I go through what's required to be submitted as part of this application, you get a good understanding of where in the project the regulator is hoping for you, where in the project that you should be when you submit this application to the regulator. So what do you have to do to comply with Gateway 3? You need to make an application for a completion certificate in relation to the HRB work or this stage of work that you have carried out in relation to your HRB or your existing HRB. The BSR will assess whether the work has been carried out in accordance with building regulations. Now, important to note is that this includes an inspection requirement. So the regulator must come and inspect the building before they can make a decision. And also part of this application is that you need to show that all your golden thread documents and information has been handed over to the relevant person. I'll come on to the golden thread in just a minute, and I'm sure you're all kind of familiar with that lovely phrase that the government has sort of created by way of the Building Safety Act, but it's getting all the information relevant to the project prepared and handed over to the person who will hold responsibility for the building after the construction project is completed. There's a hard stop in the Act, Section 76 of the BSA, of the Building Safety Act. It's that the building cannot be registered with the Building Safety Regulator or occupied until Gateway 3 is completed. So until you have that decision from the regulator, that building cannot be occupied. And if that is contravened, then the relevant accountable person has potentially committed an offence under the Act, which has the potential for a sentence of 2 years imprisonment. Let's just move to the next slide. So the BSR, the regulator, has 8 weeks to determine an application under Gateway 3. Like I said before, it includes an inspection requirement. And that deadline can also be extended if you agree with the BSR that it can be extended. There's also a consultation requirement, again, with the enforcing authority or the or the surrogate undertaker where that is relevant. And the BSR must approve the application only if they're satisfied, after taking all reasonable steps, that the work complies with all applicable requirements of the building regs, the documents are complete and accurate, and the golden thread information has been provided to the relevant person. So there's only kind of 3 qualifying requirements for the BSR to make that decision, but there is a lot of detail that needs to be submitted as part of your Gateway 3 application. Just to touch on some of that detail, there are some significant aspects which have really, I think, will shake up the new regime. Some things that jumped out, certainly to me and Ben, were that you've got to include perhaps a standard description of work, details of use of the building. You've got to focus, though, on the as-built building, not the original design. So you've got to kind of update the regulator and explain exactly what has now been sort of done as part of the construction project. And there are a number of very specific requirements in regulations 40 to 44 about exactly what detail you need to include in your application. So you need to be referring to those regulations when you make that application. The things that also stood out to us was that the client now needs to submit a statement confirming that, to the best of their knowledge, that the HRB complies with all applicable requirements of the building regulations. So that seems fairly significant, mostly because that is the building safety regulator's way of ensuring that they can rely on you, the developer, or you, the client, to kind of say that you are satisfied that it complies with building regs and that you've taken all reasonable steps to make sure that is the case, rather than perhaps just sort of relying upon building control, as it was, to kind of make that decision for you, or to allow developers in construction projects to kind of rest on their laurels and say, well, if building control have signed it off, then we're sort of ready to go. Now the onus is very much on the client, the developer, to do that. They've also want a statement signed by the client and the relevant person that the Regulation 38 documents, the golden thread documents, have been handed to and received by the relevant person. And again, that's the increased emphasis and onus on making sure that there is all of the information about the building is passed on and is available to the principal accountable person going forward. So just then moving on to another significant change with these regulations, and that is the change management regime, which you'll find in regulations 18 to 30 of the 2023 regs. So the important thing to note here is that if there is a controlled change, which is proposed by the client, then the client must ensure that there is a record made and a revised version of any agreed document which is affected produced as soon as reasonably practicable after that control change comes about. Now, a control change is any change to any of the current plans of any work or proposed work. That may seem sort of obvious and not so different from the previous regime, but what is different from the previous regime is now the need to notify and actually make an application to the building safety regulator if you have either a notifiable change and/or a major change. So these are two types of changes, two types of control changes that have been defined in the regulations, Regulation 26. And you'll see on the slide there that we've set out some of the examples of the types of major changes and notifiable changes that fall within this new regime. So your major change is a material change of use, change to the structural design, change to the active or passive fire protection measures, change to the layout, etc. Your notifiable change is change to the layout of flats, changes to internal walls, changes to construction control plan or change control plan. So the kind of less, I'd say less serious changes. But either way, whichever change you have to make an application to the building safety regulator to inform them of these changes. The way you classify your change, whether it's a notifiable or major, then depends on what you can do once you've made that application to the building safety regulator. So a notifiable change means that once you've told the regulator about the notifiable change, you can carry on with the works. You don't have to stop construction as long as they've been notified. That's the important thing. With a major change, works have to stop. No work can commence until the change control application has been granted by the regulator. The regulator has 6 weeks to consider that application or longer as agreed with you in writing. That's hugely significant and must be, I think, built in now to your time plan and your construction plan, because as I'm sure we're all aware, these sorts of changes do crop up, especially when you're building on existing high-rise buildings or changing use from an existing building to a residential building. So it's definitely something that needs to be factored into the process. Then just a quick slide on what the golden thread is, and I'm sure you're all aware of it and I've alluded to it already, but it's really important that you are on top of the information that must be included as part of the golden thread. You want to look to Regulation 31 in the 2023 regulations, which gives you the detail of what should be a part of your golden thread file. But it's, as you can see, there's quite an emphasis on it both in the Act and in these regulations to make sure that you have that information and it's up to date. Okay, over to Ben.
Thanks, Sam. I'm just going to briefly talk about sanctions for non-compliance with the various requirements now being brought in by the building safety regulator. But before I go into the detail of that, Sam, one thing that jumped out to me when you were talking about for example, the Gateway 3 and the application for the completion certificate is, as part of that, as I understand it, the parties have got to sign effectively a document that says we state that everything that we've done complies with the relevant regulations. Now, I'll be interested to hear your take on what the potential significance of that is now, particularly in light of these sanctions.
Yeah, I think there's two significant aspects of that. The first is that I think that the building safety regulator, when they come to enforcement proceedings further down the line, are definitely going to look to the person who signed that statement. And if they do find that there have been contraventions of the building regulations or any of the other contraventions you've listed on this slide in the offences section, they're going to look to that person as being the responsible person to take on that responsibility for that contravention being in place. And that's a significant, to be able to pinpoint the person involved is this kind of significant change. The second implication I would say is that it sort of gives the building safety regulator a bit of a get out of jail free card, because if the building safety regulator, for example, gets it wrong, you know, they sign off the completion certificate, your Gateway 3 application, and they say, we think it complies with building regs, and later down the line it's found not to. Well, if they can look to that statement and look to the person who signed off the building regs compliance declaration and actually pinpoint that they knew that it didn't comply with the building regs at the relevant time, then potentially they can say it doesn't matter that they signed it off, because the client should have known and shouldn't have signed that statement and should have made sure it complied with building regs before making the application.
Yeah, no, I think that well, they're both very good points, but particularly the latter one. I mean, arguably, and I know we were discussing this just the other day, I mean, it doesn't matter to some extent if the regulator gets it wrong, because if the regulator decides on the evidence that you've presented that the building complies with the relevant requirements, but then it's found that it doesn't comply with the relevant requirements, then, well, you'll still be in breach of the relevant legislation because you built something that doesn't comply with the building regs. So we'll just go back to your failure to comply with the building regs in the first place, regardless of what the regulator thinks. Which
Exactly.
is a bit of food for thought. And again, this table we've put on the slide there, that's taken directly from the Building Safety Regulator's website and sets out quite clearly, I think, what the various offences are now and the potential penalties. And as you'll see, for the majority of them, they are either unlimited fines and or prison sentences. So the government is really following through, I think, on its threat there to make sure that the building safety regulator has got teeth. And these are changes to the construction industry that will A, take effect, and B, have something sat behind them to make sure parties sit up and take notice. And on that happy note, I just want to move on to some of the commercial and legal considerations parties might want to think about. So we've talked in quite a lot of detail, and Sam has talked in quite a lot of detail about the changes that are coming in Gateway 2 and Gateway 3. Now, obviously, these will have an impact on how you tender for the work, and also will have an impact on the risk profile of those works. So something to start giving thought to now, if you haven't already, is how do you price the risk and the time required to comply with those new obligations? You know, for example, is it worth sitting down with your design team now, going through each of the requirements in the regulations and saying, is this something we do already or meet already? If it's not, how are we going to do it? Is there an existing policy or procedure we have in place that we can use or tweak, or do we have to now do something completely different? I mean, a very good example that Sam was alluding to was the change requirements. Now, if you're tendering for work and you do a lot of these, the particular type of, let's say, high-rise buildings, and you know from experience that they have a certain amount of major changes, do you include a contingency in your tender price for, say, 5 or 10 of those changes? That's something to think about. The other way to think about doing it is what happens if there is a delay to approval by the regulator, say at the end of Gateway 3, because there is an issue with the application. You know, if that issue stems from a particular drawing or part of the way the building has been built, will there be provisions in the contract to offer relief to those innocent parties? And is that going to be time and money or just time? So these are all things worth thinking about. I've also put on the slide there, what about PI insurance? Now, we know what the state of the PI insurance market is. We know it's difficult to get PI cover, particularly for fire safety, and the premiums can be particularly high. I mean, one thing we have seen in the market is obligations, for example, in the supply chain of asking parties to maintain PI insurance in order to comply with the new statutory requirements under the Building Safety Act. So that would be 15 years prospective limitation periods. So, I mean, if you are faced with that, think about whether it's something that you can also pass on to your supply chain. Is it an obligation you can even meet in the first place? If it's not, it is worth having that discussion with the other contracting party. The other point in relation to PI insurance, and this came out of a discussion I was having the other day, is that if it is expensive or oppressive in some way to get PI insurance, consider setting up a meeting with your insurer, via your broker, taking them through the processes you're putting in place or going to put in place to comply with the new requirements, and see whether that can help alleviate concerns. As I did hear a story, and I know it's only one example, but a party did that, approached their insurer via the broker, sat them down, said, this is what we're going to do to comply with our new duty holder requirements, and that led to a 10% reduction in the cost of their insurance for that year. So practically it may be something worth considering. And then the last point I just wanted to, a couple of points I wanted to make is, one is, as always, when managing risk, make sure that your contracts are back to back as far as possible in terms of limitation periods, PI insurance, warranties, etc. And also now might be the time to think about specific amendments to the contract suite to reflect the new risk profile. So got a few options on there based on things that we've seen in practice. So I have seen the bury your head in the sand approach, so you ignore it and hope for the best. We've seen the very, very detailed provisions of people trying to cover everything under the sun. Now, I don't think they necessarily work in practice, because what happens if you miss something? And also, how is a contractor meant to price for draft legislation, consultations, etc., things that might not come into force? I mean, as we already know from the consultation or consultations that happened before the raft of secondary legislation that came out 6 to 8 weeks ago, some stuff that was in the consultation has not come in, or has come in an amended form, so that wouldn't be practical. But it might be worth, and this is the last point there, considering some specific amendments. So, for example, where your completion certificate is effectively tied to completion for the sake of the your Gateway 3 application, do you need to have an interim practical completion date to aid right behaviours to that date, but also so works are able to be carried out during the 8-week period, for example, maybe de minimis type snagging works, while the regulator is deciding on your application. And then the last thing I just wanted to touch on in terms of the kind of broader impact of the Building Safety Act on businesses is how it might affect your financing or your funding. I mean, one thing we have seen recently is that the BSA and secondary legislation is now impacting on areas funders are typically interested in. So that's control over what the borrower is doing, the risk profile of the borrower, for example, and therefore funders are a bit more interested now in what steps are being taken to limit risk from future liabilities. So, for example, under the BSA, limit liabilities that might come out of the fact that the borrower now has a different profile. So is it now an accountable person or principal accountable person? They are often looking for evidence of compliance with obligations or mitigation of risk. So what is your historic liability been for defects for buildings? Or have those claims been brought under some of the existing legislation that's now amended by the BSA, for example, the Defective Premises Act? So that's something to think about. I mean, funders may also ask to see example trade contracts to see how you've been dealing with that risk and stepping down that risk to your supply chains. And this isn't, it occurred to me, just an obligation that happens when you may apply for new funding or financing, or when you're doing a new job. If your funding obligation, your funding rather agreement has amendment and restatement type provisions, or you have kind of evergreen covenants that you have to give every year, then they also might be affected. So just something to kind of bear in mind in terms of the broader picture of the Building Safety Act. And I'm just going to hand back over to Sam to give you a bit of a case update.
Thanks, Ben. Just while that's been loading, I don't know about you, but I think that now we have these 2023 regulations that have come out about the gateway process, the change process, and the other details that we haven't even touched upon, it seems to me that this is the ideal time actually for clients to go and speak to their PI insurers, to look at their contracts, because we've finally got some meat on the bones as to what's going to be required. Do you think that's right? Do you think it is a good time for that?
I mean, previously what we'd seen is a kind of a number of approaches. So the kind of, like I said, the bury his head in the sand, the really detailed provisions, or just relying on the kind of change of law, compliance with statutory requirement type provisions. I think and those varied approaches, I think, were really born out of uncertainty in the market, because nobody really knew what was going to happen. All everybody had was the consultation. There were some draft regs that were then pulled from the government website. So everyone was kind of fumbling around in the dark, for want of a better expression. But now I think you're right. Now we do have a bit more certainty, even if the kind of practical effects are not yet known. Now is the right time to revisit that, particularly because everything came into force effectively as of the 1st of October. So if you're not caught by transitional provisions, these things are going to start to bite, and they're going to start to bite very soon.
Yeah, definitely. Great. I'm just going to do a quick case law update. You've got the slides, you'll have the slides, so I won't go into too much detail. I'm also fairly sure that a lot of you will have been reading about these decisions as they start now trickling out from the courts. So just briefly, first looking at URS and BDW, and then I'll go on to look at Waite and KEDI. So URS and BDW decision that came out earlier in the year, sort of end of the first half of the year. BDW are developers, and they're responsible for the construction of numerous boxer flats across the UK, including the ones subject in this appeal, which is one in the Isle of Dogs and one in Leicester. Practical completion was 2007 to 2008, and BDW sold the apartments by way of individual contracts of sale. URS was the responsible for the design of the development. And after the Grenfell Tower fire, BDW undertook widespread investigations of all their buildings and discovered cracking in structural slabs in the development unrelated to these buildings in this appeal. But what it alerted them to was that there was structural design that had been negligently performed, so they alleged, by URS in the two buildings that were subject to this appeal. So they commenced negligence proceedings against URS before the BSA came into force. And the subject matter of this appeal was that they wanted to amend their claim so that they could include allegations under the Building Safety Act and take advantage of the extended time limits for limitation under the BSA, which is a whole separate talk in itself, but it allows you to bring claims under the Defective Premises Act for buildings that were completed from 1992 onwards, as a short summary. So the kind of significant decision of the Court of Appeal, basically in a nutshell, has established that the claims to be made by way of Defective Premises Act and under the Building Safety Act are wide open. And I've just put down some points of kind of practical relevance from those decisions for you. So the first is that the decision confirmed that claims can be brought for inherent design defects which have not caused physical damage. There was a line of case law that only linked it to, if you found physical damage, could you then bring a claim? That's no longer good case law. You can bring it even if the physical damage hasn't been found, which obviously makes sense practically, based on we know of the serious risk to persons and to life if there was a structural defect in the building. The cause of action for your claim will accrue on practical completion of the building, and the date of knowledge of the damage is irrelevant. So what was important, which Lord Justice Coulson outlined, was that essentially the defective and dangerous structural design had already been irrevocably incorporated into the buildings when it was built. It doesn't matter that you only found out much later that there was this issue with the design and the consequent effect on the building. There was, at the point of practical completion, the developer in this case had suffered actionable damage. There is a duty on design professionals to take care against the risk of economic loss caused by the construction of a building with a negligent design. And Lord Justice Coulson explained that it was a standard duty coexistent with professionals' contractual obligations. What was important for Lord Justice Coulson to clarify actually on a number of occasions throughout the judgment was that it didn't matter that BDW no longer had a proprietary interest in the building, and they discharged their proprietary interest way before, like, as I said, practical completion and then sale of the units was sort of around 2008, 2009. But what the decision does confirm is that there is this way in which if a developer acts responsibly, the courts are going to encourage developers acting responsibly because they're going to allow developers to bring the claims for those they say were negligent way after the time for when that developer was involved in the project in the first place. And that's essentially what BDW were doing here, is that they were trying to act proactively and sensibly to try to remedy the defects that they knew now existed in their buildings. As you can see there, it's the judgment confirmed that the Defective Premises Act applies to all persons and all developments. There was an argument run in the case that the DPA only applied to individual dwellings rather than a whole development, which is what the principal designers had been responsible for, and Lord Justice Coulson gave very short shrift to that argument. What it goes to show is that the Defective Premises Act, as you're probably all already aware, is really going to be a key act that's now been kind of reinvigorated as a result of the Building Safety Act. I've already touched on the first point on this slide, so I think the remaining significant aspects of the judgment is what Lord Justice Coulson said about contribution claims. Now, you all have probably all come across this, is that there are actually numerous parties that have in some way liability in relation to completion of a project and dealing with the matters that now need to be rectified because they demonstrate building safety risks or risks for structural defects in the building. And the way to bring a claim is under the Contribution Act. Now, an argument that was run in the decision was whether you have to wait until a formal claim has been established, you know, kind of between the two key liable persons, the claimant and the defendant, before then you can kind of go after third parties to then seek contribution from them. And what the Court of Appeal said was that no, you don't have to wait for that formal claim to have been served, established, found. That is not required by the Act. You can bring contribution proceedings even without even without that formal claim having been established. So I think the important practical implication of that is that if you are someone who is either making a claim or has been put in the firing line of being subject to a claim, and you consider there are other parties who are potentially liable for the works, for the defects, then there's no need to wait. You need to bring those people in, those parties in ASAP, and you can do it under the Contribution Act as your cause of action. And then, as I said before, the retrospective time limits provided for in the BSA, the judgment confirmed that can be used in ongoing litigation. So the BDW could amend their claim to now bring in the provisions that were applicable to them under the BSA. Okay, and then the last slide deals with the title of that is actually incorrect. Apologies. It's WAITE, W-A-I-T-E, and KEDI Limited. Now, this is the recent decision that has come out of the first tier tribunal. It's the first decision that has been made where a remediation order has been made under Section 123 of the BSA. And as you'll probably know, remediation orders are where, for example, leaseholders can apply to a developer or a freeholder to ask them to compel them to remedy relevant defects in the building. And a relevant defect is one that causes a building safety risk, which is essentially either a risk of fire spread or risk to the structural integrity of the building. The decision is an interesting one. It's really well set out. It's very clear and easy to read. And I think some of the important points that have come out of it are this that I've outlined on the slide. So the subject matter of this, just to run over it very briefly, was that there were 2 blocks in a development in Streatham in London, where the leaseholders had identified that there were defects that needed to be remedied. You know, all the similar defects that have come out of the Grenfell Tower fire. So the cladding, lack of fire stopping, lack of cavity barriers, issues with compartmentation, issues with the fire cement external wall system. And the respondent, KEDI, accepted that some of those defects needed to be remedied, but argued that the tribunal didn't have the evidence to make a remediation order, essentially kind of wanted the tribunal to step away and allow the developer to try and remedy the defects under their kind of own terms and regime. So the leaseholders weren't happy with that and made an application to the tribunal. And the tribunal, again, has sort of thrown open the doors to remediation orders being made in all sorts of instances. What they confirmed was that the BSA has created a freestanding regime concerned with removing a relevant defect. So you don't need to look to the building regs, you don't need to look to the fire safety order. This is its own regime, and the tribunal are going to apply their own expertise and knowledge and anything they gain from inspection of the building to make a decision about whether there is a defect that falls within the definition in the Act, and therefore whether a remediation order should be made. Interestingly, they've decided that they will determine what a relevant defect is against what is currently known. So we have an issue in these cases where you have these buildings that have been built a number of years ago. At the time, they were signed off by building control, they were signed off by the enforcing authority. But now we have a change in the state of knowledge because of mainly what happened in the Grenfell Tower fire, with a change in whether the cladding causes a fire risk, whether the design will cause a fire risk or a structural failure. And what the tribunal said is, it doesn't matter, essentially, that building was signed off all those years ago and the local authority and the enforcing authority was happy with it. The important thing is, if it currently presents a fire safety risk and therefore meets the test of a relevant defect, that is going to be a problem that needs to be remedied. So that sort of means that you can't run the arguments that it was previously approved. The other interesting aspect is that when it comes to what the developer needs to do in terms of the remedial work, as I've said at the bottom of the slide there, is that they said that the developer needs to comply with the current building regulations and satisfy PAS 9980 2022. And that's interesting because, again, you have these buildings that were built a long time ago and complied with the building regulations that existed at that time. And as you know, ADB, for example, doesn't have a retrospectivity provision in it, but the tribunals say that now any remedial work you do has to comply with the current standards. And that seems to be a significant change in the way that these projects are going to have to be approached. I'm going to end it there because there's a lot of other interesting aspects of the decision, but I want to leave some time for a bit of Q&A.
That's brilliant. Thank you both very much. That was very thorough, very interesting, and I hope we're now all completely up to date, particularly with mention of the new information about the regulation of military barracks, which only came out this week. There's just time for a few of the many questions that have come in. There have been one or two sort of clusters of questions. There have been 2 or 3 questions around completion, practical completion, and just to prove that I was paying attention, Ben, I noticed you referred to interim PC dates, but the 2 questions that will come in, I think they're related. When should you make your Gateway 3 completion certificate application? And are we seeing, or how do we see Gateway 3 being incorporated into building contracts in terms of practical completion? I don't mind.
I might ask Sam to maybe do the first bit of that question.
Yeah.
So when should you make your application, and I'll maybe pick up the second bit.
Yeah. So as I alluded to earlier, it's not clear what completed means, but your application, you do need to say that you do need to include in it a notice that says the date on which the building work was completed. So it seems to me that that means practical completion, but potentially not the snagging work. So it might be that then you can use that 8-week time period while you're waiting for Gateway 3 application to be decided upon by the BSR to carry out that snagging work. But as far as I can tell from the regulations at the moment, it's just you've got to be confident that the building work has been completed.
Yeah, and I think that then feeds into the answer to the second bit of the question, which is how might you kind of police that in terms of your construction contract? And I think the answer to that is, well, you could tie it to PC, but then you've got the risk of, as we know on lots of projects, that everything gets left to the last minute. So when you get to PC, everything's happening at once. And in order to avoid that risk and to give yourself enough time to make sure you put your application in with the sufficient detail, etc., it may be a better idea to have some kind of interim PC date or target date that the parties have got to hit, potentially with its own risk and reward type provisions, so a payment of some form of retention release on that date, or an LAD provision, just to encourage people to hit those dates. And then that will then give you the period after that, as Sam says, to do what I expect would have to be fairly de minimis type snagging, in terms of how practically you could manage that process.
Okay, no, thank you. That's something, that's quite a lot to actually think about. When you sort of, okay, brilliant. No, that's really helpful. Changing tack a little bit. Been asked, what happens if the regulator makes an error in deciding or determining that the building is compliant with the various regulations or requirements?
Yeah, well, this is something that we, Sam, if you don't mind, I'll take this one. There's something we talked about, I think, in the talk, which is ultimately, well, there's 2 points here. Number one, if you think the regulator has made an error, there is an appeals process provided for in the regulation, so you can appeal a decision. Number one, if you think they've got it wrong. Number two, if they make an error, for example, they say your building is compliant and it's not, then I think that will really come down to the facts of whether it is in fact non-compliant or not, and whose fault that is. And I suspect that it won't really matter what the regulator says. And as Sam kind of rightly pointed out earlier in the talk, you will be signing a compliance statement, in your role as client or contractor or designer, saying it has complied with everything it's meant to comply with. Remember that very, very broad test of all relevant obligations. So I think that the regulator would, in any event, would just point to that and say, well, you made that statement. This is not our lookout, as it were. Which is, I appreciate, might be unsatisfactory, but I think that will be the reality.
Yeah.
Okay. Well, I mean, I can see that makes sense, and it seems like sort of the safest course. Although, as you say, I can see there's some unsatisfaction if the regulator sort of says something that turns out to be wrong, but you are ultimately responsible because you're the people that have been responsible for the building. Yeah. Okay. I can see that. Just quickly, because we are out of time, I suppose, sort of more way of general comment, perhaps, or just, I mean, you've talked about all these rules, regulations, and we know that there's probably more coming in. I mean, is residential high-rise ever going to appeal anymore to contractors, developers? On top of the regulation, you've got reduced lettable floor space and other concerns about people actually using these buildings. I mean, what does your crystal balls sort of say?
Sam, do you want to go first on this one?
Yeah, I mean, it looks increasingly unattractive, doesn't it, to build a high-rise building? But we also don't have the real estate or the land to build anything less. So it could be that we are going to be seeing buildings of 17.5 meters being built, and more of them. But the tricky thing is that the Building Safety Act actually doesn't only apply to buildings of over 18 metres. There's a lot of provisions in there that would cover a talk in and of itself that actually apply to buildings of over 11 metres in height. So it seems like, for my sort of crystal ball gazing, that developers and contractors are just going to have to try and find a way to economically and efficiently deal with the changes that have been brought about by the BSA.
Yeah, I think that's right. And I think the other thing you might see is maybe very, very tall buildings being built so you can get the economy of scale that you need for dealing with these. And the last thing I would add to that is ultimately the cost of building these types of buildings is going to go up. The risk profile is going to increase. And so what I expect you will see is two things. Number one is the developers who do these developments will be the ones with the deep pockets. They'll be the big established companies. Smaller companies, I suspect, will move away from it because they don't have well, there isn't the money in it for them anymore. And number two, I suspect that the ultimate cost then of buying flats and apartments in these buildings will increase. So the consumer will, at some point along the line, pick up some of the tab.
Yeah.
Okay. Well, thank you very much, and thank you again, Samantha and Ben. I'd say very interesting, very informative, and I suspect, given how fast-moving this topic is, we may be inviting you both back quite early in the new year. But there's just time for me to say that hopefully you can join us for what will be our final webinar of 2023, where Claire King, a partner, and Matthias Chung from Essex Chambers will be looking at bonds and guarantees and setting out some of the key considerations that you need to be thinking about in the current difficult economic climate. So thank you all very much for joining us today, and thank you all very much for your questions, and hopefully you'll be able to join us again on Thursday, 16th of November. So thank you very much, and goodbye.